Folks, we're on the eve of closing arguments in the case of Kellen Winslow II, and the case moved very quickly. 5 accusers, really 5 trials in one were tried, and we're done already with all the evidence, unbelievably. Let's bring in Court TV legal correspondent Chanley Painter, who's live outside the courthouse in Vista, California. For those of you who haven't been to Vista, it's just north of the city of San Diego, but still in San Diego County. All right, Chanley, the jury was instructed today, which I understand is usual there, to do it before closing arguments to give them some of the legal instructions, and we've got copies of them here that you sent us. Thank you very much. Was there anything that you noted in those instructions that was a little bit unusual or noteworthy?
Absolutely. So the jury will have some complicated instructions on a couple of issues. And so the prosecutor, Dan Owens, will really have to give them a crash course, almost a legal course, on how to apply these instructions to the law and the facts and all of that. And a couple of things stood out to me. One had to do with something we've talked about for a couple of days because the defense objected to the 1101B instruction, how you can use evidence from one case and apply it to the other as proof. So what they did is they actually narrowed it down for us. They actually narrowed it down to Jane Doe number 2 and Jane Doe number 1, Vinny. So if they find that Jane Doe number 2, the charges against her were beyond a reasonable doubt, they can use that as consideration to find the intent for the kidnapping of Jane Doe number 1. And now usually that would be a preponderance standard, but here the prosecutor seems to be very confident in his case, and he said, I'll agree to raise that to beyond a reasonable doubt for Jane Doe number 2 to Jane Doe number 1. So I thought that was really interesting. And then secondly, the statute of limitations issue for Jane Doe number 4, because it is an offense from several years ago. To toll the statute of limitations, the prosecutor has to present independent corroborating evidence other than Jane Doe number 4's testimony. So the jury won't know they're making a statute of limitations finding. They just added a couple of elements to the jury instructions to say, hey, is there independent corroborating evidence? And that will be a question for the jury.
Wow. All right, let me bring back in my think tank here in studio with me. And Lieutenant Colonel, let's talk about investigating a case from 2003. And she came forward after the other Jane Does were in the news already, but came forward with her story. And from your perspective, how well can you investigate something, an allegation from 2003?
It's very difficult because people move. People unfortunately die sometimes. You know, you have witnesses that may no longer be with us. They have witnesses that are very hard to find, especially if you have witnesses that may be homeless. It was not the case here, but possibly in Jane Doe number 1 or 2, if they were homeless and they had a witness, you know, their witness may be homeless. And how do you find someone that's homeless? So it's very difficult to go back that far and investigate a crime with little to no evidence, only hearsay, basically. And
yeah, what you have is her story and the story that she told to others, Ray. Is it fair from your perspective?
Well, I'm not in the fair business. I'm in the win business, Vinny.
All right.
And sexual assault cases, the faster they're investigated, as Lieutenant Colonel points out. So let's just take this. Where was the room? Where was the video? Where are the bedding, the torn clothing? Who's the outcry witness? Who saw them come in? Who saw them come out? Did they have alcohol in their breath? Were there drugs? 13, 20 years later, those things are very hard to put back together. Now the science, and as we both know, the DNA science has gotten so good, that is actually probably the easier part, where 20 years ago was the harder part. But when you're depending on eyewitnesses and recollections, even professional witnesses, and what I mean by that is law enforcement trained folks, 20 years later, I'll cross-examine them till I melt them like a candle.
Yeah, and Rachel...
That's why you need Mr. Vaughn. I mean, I think that's why you would give
Why
him
who needs him?
Why the state would need him if they're going to suggest that they need some sort of corroborating evidence due to the statute of limitations issue. I know that her friend testified, except she wasn't in the room. If Jane Doe number 4 testified, this other individual was in the room.
Yeah.
His testimony would corroborate it or not.
And again, the way, as Vic pointed out, give him immunity. Obviously, the danger there for prosecutors is it looks like you're making a deal with a rapist, right?
Absolutely. You hit the nail on the head. That's exactly the problem. And let's look at this through the lens of the climate of certain types of prosecutions throughout the United States, and especially here in California. We are traditionally a much more liberal state generally, aside from a few very distinct conservative pockets. But you have seen, and I have seen over the past 20 years, how this type of prosecution has changed. And one thing we're not talking about is how easily a prosecutorial agency goes after these charges. It used to be the case that regardless of the law, practically speaking, that district attorneys, investigators would have their own screening process. Do they have enough to believe there's reasonable suspicion or probable cause or a good gut feeling, whatever the standard may be, to turn that over to a prosecutorial agency? And then the prosecutorial agency, of course, would comb through the forensic reports, the live testimony, or the percipient reports and say, well, do I have enough probable cause to file charges against, in this case, for instance, Mr. Winslow Jr.? Well, in this climate that we're in now, that is almost a death knell for any prosecutor who may be running for re-election anytime soon. Because you just practically you cannot attack or cross-examine a complaining witness's complaint, which is what I think leads to some holes in these stories.
All right, we got a lot more to talk about, folks, but I want to hear from you, our 13th juror. You know who didn't testify?